profusely elated to take an opportunity to introduce our chief guest of today's inaugural function of the one-day national seminar, Honorable Justice Bhushan R. Gavai, Judge, Supreme Court of India. He is the Chancellor of Maharashtra National Law University, Nagpur, former Judge of Bombay High Court. At the age of 25, your good self has enrolled as an advocate and started practicing at the Nagpur bench of the Bombay High Court. He was appointed as a judge of the Bombay High Court in 2003 and served in that position for 16 years before being elevated to become judge of the Supreme Court. The Collegium, in recommending him, gave due weightage to his seniority, integrity, merit, and due representation in the Supreme Court. With immense admiration, I once again welcome you, sir. Kindly accept our sincere regards. And please come forward to enlighten us for your inaugural address, please, sir.
A very good morning to all of you. Dr. Faizan Mustafa, the learned Vice Chancellor of Nalsar, the Vice Chancellor of Dr. Bhimrao Ambedkar Law University, Jaipur, Honorable Shri Dev Swarupji, the Registrar of the University, Shri Ayub Khanji, all the other office bearers of the university, the learned registrars of the Rajasthan High Court present here, Shri Parihar, the Additional Advocate General, Rajasthan, and the other members of the bar present here, the representatives of the various managements under whose auspices the law colleges are being managed, the principals of the colleges, the members of the faculty of the colleges as well as the university, the representatives of the media, and above all, my dear student friends. At the outset, I convey my heartfelt greetings to all of you on the 131st birth anniversary of Dr. B.R. Babasaheb Ambedkar. I also convey my greetings to one and all on Mahavir Jayanti. It gives me a great pleasure to be with you all this morning. I must congratulate the university for organizing such an important event to coincide with Dr. Babasaheb Ambedkar's 131st birth anniversary. And all of us know that Dr. Babasaheb Ambedkar's contribution is in variety of fields. As all of us know that he was a great economist, he was a great sociologist, he had a vast comparative study of various religions. He was a lawyer, a great lawyer. He was a social reformer. But I think the two major contributions which will be always remembered in the golden words of the history of the country would be his work for emancipation of Dalits and last but not the least in being the main architect of the Indian Constitution. All of us know that Dr. Ambedkar had always differences on ideology with the Congress. But in spite of that, he was chosen not only to be member of the drafting committee, but as a chairman. After the establishment of Constituent Assembly, the objectives resolution came to be placed before the Constituent Assembly by Pandit Jawaharlal Nehru on 13th of December 1946. As per the turn, Dr. Ambedkar's turn was to come much later, but on 17th December, he was called upon to speak on the objectives resolution. And though he was not prepared, he addressed it. He said that I am disappointed with the objectives resolution. The philosophy of the Congress has always been towards achieving political, social, and economic justice. But I do not find any positive note in the objective resolutions. There must have been something more in the resolution which would show the commitment of the Constituent Assembly to achieve social, political, and economic justice. And therefore we know as to how dear the thought of social, political, economic justice and equality was to his heart. And then when India became free on 15th of August 1947, within a fortnight, on 29th of August 47, he was chosen not to be only a member of the Constituent Assembly, but also to chair it. As all of us know that the Constituent Assembly put in a hard work and relentlessly labored for a period of almost 3 years. Various amendments were proposed, they were opposed. Elaborate discussions were held even on small matters like entries in the 7th schedule, whether it should be in list 1, list 2, list 3. And Dr. Ambedkar, along with his colleagues in the drafting committee, had to handle all these amendments. Most of the amendments which he accepted went through, and most of the amendments which he opposed were not accepted. Unity of country was closest to his heart. If you read his speeches prior to India becoming free and the unfortunate partition, he always advocated that there has to be one India, and he said that I am sure that the Muslim League would agree and to be part of an India. Unfortunately, that did not go through. He always used to say, I am Indian first and Indian last. He was also criticized that the Constitution leans more towards the central government and does not reflect the federalism in true spirit. He rejected that argument and said that we are giving a constitution to the country which will keep the country united and strong in times of war as well as peace. As I already said, I am taking a cue from what my predecessor, a very learned man, has said about the social and political justice. As all of us know that there was a debate that there has to be something in part 3 of the Constitution which will take country forward towards the social and economic justice. However, as already told to us by Dr. Mustafa, that Dr. Ambedkar was not a free man to frame a constitution of his will, and therefore compromises were required to be made, and whatever he could not bring in part 3 towards the goal of achieving social and economic justice, that was brought by way of part 4, the directive principles of state policy. A criticism was made on Dr. Ambedkar that directive principles are nothing else but a post-dated check on a bank-run bank. A criticism was made that though the rights in part 3 are fundamental and a citizen can knock the doors of the court for if there is a violation, there is nothing in the part 4 which makes it obligatory and no remedy is given to a citizen to enforce them. Dr. Ambedkar replied that I am willing to accept a criticism that it is a post-dated check, but I am not willing to accept a criticism that it is a post-dated check on a bankrupt bank. He said that I am sure that one day the bank of my country will be so strong that the post-dated check that we are giving today would be encashed. Two of his speeches, the one on his opposition, on his criticism to the objective resolution, and the second one, that is on 25th of November 1946, a day prior to the adoption of the Constitution. Like all other speeches in the Constituent Assembly or otherwise, make a great reading, and as a student of law, as a student of Constitution, I would also like my other student colleagues to go through them, Dr. Ambedkar said that for achieving social, economic and political justice, we must have a trinity of equality, liberty and fraternity. He said that liberty alone would not be sufficient, because then it will give rise to a laissez-faire. A stronger will become stronger and a weaker will become more weaker. He said that equality alone would also not be in the interest of the country, because a person will lose an incentive, he will have no incentive to excel, to compete with others, and therefore liberty has to coexist with equality. And he said, we require a fraternity. A fraternity will act like a policeman to see to it that liberty and equality do not fight amongst themselves and both act along with each other. And therefore he said that liberty, equality and fraternity not alone, but trinity of all those three are necessary for social, political and economic justice. Dr. Ambedkar cautioned that on 26th of January 1950, we will be entering into an era of contradictions. He said, we have assured justice, political, economic and social to the citizens of the country. On a political plane, by the principle of one person, one value, and one vote, we have tried to achieve a political democracy, political justice. But what about social justice and economic justice? On an economic plane, we have a society wherein economic wealth of the country is concentrated in few hands, and on a social plane, we have a society which is compartmentalized into 4 compartments, and that too, a movement from one compartment to other compartment is barred. He said if we fail to remove these contradictions, the edifice of democracy, which we have so laboriously built, will collapse like a house of cards. And in this background, I would like to briefly survey the journey of our Constitution in last 70 years to have a review as to whether, to some extent, the expectations that were expected by the Constitution makers have been fulfilled or not. As I already said, Dr. Ambedkar always used to say that I am not a pessimist man, I am an optimist man, and I am sure that the expectations which we are having on the future generations would not be belied. As I have earlier said, that the main object of bringing directive principles, the part 4 in the Constitution, was to march a goal towards the social and economic justice. As has already been observed by Dr. Mustafa, that the earlier dissents have now become the majority view. Law is organic, law is growing, and law is not static. And therefore, a criticism of the judgment should always be welcome. Judges are also human beings, and they can also err. As a matter of fact, when I was in High Court, I have myself held my 2 earlier judgments to be per inquirium. If one errs, there is nothing wrong in accepting one's error. In Supreme Court, you have to be more cautious. In High Court, one could always say, I may be wrong, there is one more court to correct me. But now, you can't say it here. And therefore, as all of us know, that the earlier view of the Supreme Court was that in a conflict with directive principles and fundamental rights, the directive principles will have to give way to the fundamental rights. The view was that the fundamental rights are superior to the or restoration of the lands in favor of scheduled caste, scheduled tribes, the tenancy laws, the agricultural land silics acts. We have seen that the Supreme Court has, or as well as the other high courts, have always been in favor of protecting such laws which were made in furtherance of the constitutional goal of social and economic justice. Dr. Ambedkar's contribution in making of the Constitution, as all of us know, is unparalleled. And when the Constituent Assembly was on the verge of finalizing the Constitution and accepting the draft Constitution as proposed by Dr. Ambedkar, that he has framed Bhima Smriti. I also call it Bhima Smriti, though he belonged to the Asprusha classes. Dr. Ambedkar is a great lawyer and a man of great ability and intellectual. Nobody will doubt that. Mahavir Tyagi states, and I quote, "I stand today face to face with the picture of my old dreams and that fruits of my tremendous strenuous labors of 30 years. A concrete picture is before us. Dr. Ambedkar was the main artist, has laid aside his brush and unveiled the picture for the people to see and comment upon." Lastly, I will refer to Dr. Rajendra Prasad, the first President of India and who was also the Chairman of the Constituent Assembly. He said, "Sitting in the chair and watching the proceedings from day to day, I have realized, as nobody could have, with what zeal and devotion the members of the drafting committee and especially its chairman, Dr. Ambedkar, in spite of his indifferent health, have worked. We could never make a decision which was or could have been so right as when we put him on the drafting committee and made him its chairman. He has not only justified his selection, but has added luster to the work which he has done. And therefore, I am really happy that the Rajasthan government has established the Law University for the affiliated colleges in the state of Rajasthan in the memory of Dr. Bhimrao Ambedkar, who was the main architect of the Constitution of India. It is a befitting tribute to the person who has laboriously put in his service for making the Constitution, as said by Dr. Mustafa, that it is one of the finest constitutions that we have. It is a constitution which still holds the country united. We all know that what is happening in the countries around us. I don't want to name any country. But let us compare ourselves with what is happening in the neighbor nations which are established almost at the same time. We still have a rule of law. We still have a strong democracy. As all of us know, that this conference is mainly focused, it's really a great endeavor on part of the learned Vice Chancellor, Dev Swarupji, who has in a short period taken this university to the heights that it has reached today. To have a conclave wherein all the stakeholders, the managements, the principals, the faculty member, and above all the teachers would interact with each other and try to evolve the methods which would enhance the quality of legal education to be imparted in the affiliated colleges. As all of us know that at one point of time, the legal education was lambasted upon like anything. We had the law colleges either in the morning hours or in the evening hours, where many of the students were working in some establishment and doing law as a part-time course. The faculty was the lawyers who were practicing in the courts. I am also a product of one of such law colleges. But the times changed. The law education was lambasted as a factory to produce half-baked lawyers who are nothing else but thrust upon the society at its parasites. Maliwat Commission made various recommendations for the changes in the law colleges. Subsequently, we had establishment of the first National Law University at Bangalore, thereafter Nalsar, then Calcutta, and now we have almost, I think, in every state, the National Law Universities. I am also associated with one of such National Law Universities at Nagpur. But the grievance is that these universities cater to the specialized classes. Most of them either serve in the corporate sector or work as solicitors. As all of us know, that law is not only a profession. Lawyers are social engineers. The lawyers have to contribute to the society, and therefore it is the lawyers who study in the colleges either at the district level or the Mufassil level will cater to the society at large. It is they who will be practicing in the trial courts, in the district courts, and catering to the needs of the majority of the citizens of the country. And therefore, I am really happy that the university has decided to coincide today's conclave along with Dr. Babasaheb Ambedkar's 131st birth anniversary. Dr. Ambedkar used to say that his mantra was educate, organize, and agitate. He always used to consider education as a milk of a tigress. He used to say that the rights only are of no use unless the people are educated and they know that they have their rights which can be encashed. And therefore, this symposium on the day of his birth anniversary, in his memory, I feel is a great tribute, a great initiative by the university. I must congratulate Dev Swarupji and all his associates for organizing the same. Coming to the well, I'm supposed to finish by 12:55, but I started 15 minutes late, so I will just take half of that 7 or 8 minutes. As I already said, that the journey of the Indian Constitution for last 70 years has been positive. A journey of 70 years cannot be said to be a very long journey. And therefore, in retrospect, we look at the vision of Dr. Ambedkar or other framers of the Constitution. The question that we will have to ask ourselves is as to whether we have totally failed. And fortunately, my answer to that question would be no. The journey has been positive. Dr. Ambedkar always used to say that the most Shudras in the society are women. Women are considered to be more Shudras than even the untouchables. Coincidentally, we have celebrated the birth anniversary of Dr. Mahatma Jyotiba Phule a few days back. It is Mahatma Jyotiba Phule and Savitribai Phule who opened the doors of education to the women. The situation was so pathetic when Savitribai Phule used to go to the school to teach girl students. The Orthodox Dr. Mustafa, the shift is in a positive manner. The earlier view was that Article 16(4) is by way of an exception to Article 16, but that was a view. And the 7 judges in the case of Thomas, what was earlier a minority view became a majority view. And it was held that Article 16(4) or 15(4) cannot be an exception to the main clause of Article 16(1) or 15(1). It was said that it is an emphatic way of stating what is already inbuilt in Article 14, 15(1) and 16(1). It was held that what Article 14 provides is equality, but equality amongst equals. Equality not amongst unequals. It was held that if we construe the equality clause to be equality amongst equals, it will again widen the gap between unequals and unequals. So therefore, an unequal treatment to unequals is permissible is inbuilt in Article 14, Article 15(1) and Article 16(1). And now we see many of the persons from the scheduled caste, scheduled tribe have adorned the posts of the chief secretaries of various states, the director generals of various states. We have had 2 presidents of India belonging to the scheduled caste category. We have had a speaker of the Lok Sabha who belonged to the scheduled caste category. We have had the Chief Justice of India who belonged to scheduled caste category, and therefore it cannot be said that we have not achieved anything in the journey of last 70 years. The learned comparer, while giving my introduction, did not mention one sentence. She mentioned that in the resolution of the collegium recommending my name, it was stated that looking at his ability, integrity, and so on, his name is being integrated, is being recommended. She also stated that it was being recommended to give representation. She missed out on that the resolution also stated that for last decade, there is no representation to a category belonging to a scheduled caste, scheduled tribe, and therefore, in order to give representation to that category, it is necessary that his name should be recommended. And therefore it is because of the Constitution interpreted by the Supreme Court of India in the second judge's case, we said that while ensuring merit, it said that India is a country of diversities, geographic, social and economic. And therefore, while making appointments to the Supreme Court, while ensuring that merit is not compromised, an effort should be made to give representation to all parts of the country and all sections of the society. And it is because of the interpretation of the Constitution by the Supreme Court, I am before you today. I am happy that I am getting an opportunity to address the students. The students are the future of the country. Dr. Ambedkar considered Constitution as not a book, but an instrument of social revolution, an instrument to bring out change. And it is my dear students and the dear faculty members who can achieve that. The law students of today are tomorrow's lawyers, tomorrow's judges, tomorrow's ministers, tomorrow's parliamentarians, tomorrow's bureaucrats, and to shape them up is the duty of the faculty member. I am sure that the symposium which has been organized today will go a long way in producing citizens of India who will take ahead the dream of Dr. Ambedkar of achieving social and economic justice and bringing about the equality in real sense. Thank you very much for giving me this opportunity.